Imagine cops messing up so bad that a judge has to blow raspberries on their incompetence. Here are moments when judges save people from evil cops. Did you know that charging your phone can get you arrested? Well, that's exactly what happened with Samuel here.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven. In the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under Penal Code.
Oh, come on. They charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the...
I know, but that's the contact to get to him.
Yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean you can't have it.
And so what? So they go up to him, they start talking to him.
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he said his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
The defendant had outstanding warrants and was placed in custody.
Right, they was.
He was charging his phone.
What do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on.
So Samuel was using an outdoor outlet to charge his phone when police officers arrived and started questioning him. Their defense is that the alley is supposedly infamous for criminal activities and our guy didn't share his ID with them. But do you think the questioning is lawful? I'll let you decide. According to the cops, he was then arrested for failure to ID and theft. Not sure where the theft angle came from. The judge had heard enough, and it's time for justice.
Okay, so first we have, that's Rivera and Soto?
Duoto, with the D.
Oh,
I
Duoto,
know
right.
I mispronounced it, so. Pronounce it one more time? Duoto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the...
Dismiss the theft?
Yeah.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it. You know, most times people plead to the theft case and it really hoses them, because then you're looking at, you know, not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served. What time are we looking at?
Rojas?
No, Duato.
Oh, 18/6.
18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this.
So charging your phone is not a good idea. How about self-defense? Apparently, crooked cops don't like that either.
DeAndre Heath, come up, sir. Good morning, sir. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
yes, Judge.
It's another person.
And it's just the way
Yeah.
this is pled is because he's underage, he's below the age of 21. That's the way it's pled, Your Honor.
This 17-year-old waved his gun at a person trying to attack him and his brothers for self-defense, but that didn't sit well with the police officers. Even though the judge is not convinced of the probable cause here, a guardian angel comes running to join the scene.
Hold on, I'm gonna go yell at somebody. Hold on.
Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
No, hold on.
hold on a second.
Here's
Wait a minute.
GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer. I volunteer representation. Yeah,
Give me a record, can you fill that out? please?
I will do that. But here's a GPS memo saying that it's
Hold on a second.
unconstitutional.
You know, representative gentleman?
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Here you go, Mr. Tito.
Thank you.
Judge.
I was
is
gonna,
there PC?
yeah, look, you gotta be very careful, you know, God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life at 7. The more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. It's going to get dismissed. Be careful, friend.
And just like that, the cops made a mistake to arrest this young man, but the judge made no mistake in making sure justice was served and blessed the lawyer who volunteered like a madman on a mission. The case was dismissed just like that, and Mr. Heath walked a free man. And how about some shopping drama? Apparently, you become a suspect if the store manager sees someone else stealing stuff from them. These cops would arrest people for anything these days.
So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 27, 2025, an officer was working a second job at Dick's Sporting Goods in Harris County, Texas, and was approached by the store manager, the witness. This advised the officer that the defendant walked in the store with another individual, and the witness advised the officer the other individual with the defendant walked out of the store without paying for any merchandise. The complaining witness stated he wanted the defendant to trespass because the defendant was seen on camera attempting to cover the individual while the individual was stealing merchandise. The officer stopped the defendant at the front entrance of the store, and the officer stated the defendant would be trespassing the store. The defendant became irate and more aggressive. The officer ordered the defendant to place his hands behind his back and placed handcuffs on the defendant's right wrist. The defendant twisted his body and tensed his muscles. The defendant, with a great amount of force, threw his left arm forward and threw his left arm backwards towards the officer. The officer attempted to gain control of the defendant's left arm. The defendant began pulling away, and the officer grabbed the defendant's body with both arms and guided the defendant toward a rack where the officer was able to excuse me, Your Honor, tongue twister, where they were able to contain the defendant. The defendant was identified by his Texas driver's license.
What's he under arrest for?
Just to make things clear, someone was stealing from the store, But not Jordan, who was arrested. He was out there minding his business until he was arrested. Something feels fishy, right? And here's the million-dollar question.
What's he under arrest for?
I believe he was under arrest for trespass originally, Your Honor.
No.
We have.
You gotta,
Yes, Your Honor. You just have a brief moment.
are you losing? Are you losing?
There's a reason they say anything you say can and will be used against you in court. So if you're winning, just win. Don't speak anything, as it may end up harming your case. And that's exactly what the judge did here. So no, he was not being rude to the defendant. Instead, he was helping him win.
Your Honor, the only thing I have is that the suspect began acting irate and clearly becoming more aggressive. And then the officer went to detain the suspect by grabbing his right wrist.
No. When you get into a pissing match with the people who have the power of arrest, who's going to win every single time? You know what I mean? Every single time. Sometimes it's better to tuck your tail at times, because you may end up winning in the long run. I'm going to find no probable cause in the case. Just be careful, man. I probably wouldn't go back to the sticks because it's not going to go well. You know what I mean? All right, hang tight.
Even the lawyer couldn't find a reason for this unlawful arrest, let alone the cops justify it. And as you could guess, the case was tossed. So you can't shop with a free mind. How about shaking hands? What could go wrong?
The officer observed the defendant speaking to two other individuals and conducting a hand-to-hand transaction. The officer stopped his vehicle near the defendant, and when the defendant saw the officer, he started leaving on his bicycle. The officer began to follow the defendant, and the defendant actively avoided the officer by changing directions frequently. The officer stopped the car and told the defendant to stop. The defendant continued to flee until losing his balance on his bike, and the defendant stated he did try to flee because he had an active parole warrant. So
What was he doing wrong?
the officer observed what appeared to be a hand-to-hand narcotics transaction.
Okay. Was the other person doing it? Did he do it?
It was
Did they find any dope?
probably counting up, but what they did observe was him on his bike and stopping with someone else.
And didn't even notify himself as police. You know, one of the conditions on an evading arrest is you have to notify that you're a police, that you're a police officer. You can't just yell stop.
So there was no exchange of any material, and upon search, nothing illegal was found. So how do you think the crooked cops found the man guilty and arrested him for a narcotics deal?
Let me see the DIMs.
Sure.
You have that the officer was riding in a marked patrol vehicle as he was following the defendant. So there is that, as well as
Does that imply?
My client was on a bicycle. He was riding a bike.
and that's when they were following him in the marked patrol vehicle while he was on his bicycle, and then yelling at him to stop.
Did they find any evidence of a narcotics transaction? They obviously didn't find him with any dope. Did they find him with like a large cash? And then let's look at the statute. What is your argument?
Well, my argument is that he was just riding his bike. In the DIMS, it does say, and I quote, where did I just lost it? The defendant looked at me and attempted to flee. I don't know how you attempt to flee.
Well, I guess just go the other way from him.
That's fleeing though.
And then it says in the DIMS as well that the officer observed the defendant look at the marked patrol vehicle and then change directions as he
You
viewed.
know how many people do that? You know how many people just look at a police car? I do it too.
Yes, Your Honor.
He's also riding,
Sure too.
he's riding a bicycle. He needs to pay attention to traffic.
And Your Honor, the only thing is that that took place after what appeared to be a hand-to-hand narcotics transaction. That's what the officer wrote in the DIMS.
Yeah, I'm not buying it. All right,
Yes,
no
Your
problem.
Honor. Yes, yes.
Thank you, Judge.
Arresting people on bicycles? The cops never cease to amaze us. And then the prosecutor goes on to say that the rider was swerving, hoping to make it make sense, but of course it doesn't. Even the judge establishes that he does that too. He's truly the judge of the people, and of course, another case canned for lack of probable cause. A prosecutor is supposed to work hand in hand with the cops and make sure that the streets are safe. But does that mean they can fabricate stories? Let's find out.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always.
Did I hand you DeContal versus State? I did, just,
You can tell.
yes.
Yeah.
Um,
Oh, look, it's out of court 8 in Harris County. So why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He
he's
doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video. We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they had to push him back into it.
The reaction from the defense lawyer is amazing. The prosecutor is saying one thing, which of course is trying to justify the cops, but the truth will soon be found.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch it now.
We can watch the video, Judge.
Cue it up. Let's watch.
I'm just turning the volume up, Judge, as well.
And then the video from the police body cam was played by the prosecutor in full confidence, but she had no idea what would happen next.
What the hell is that?
Now you got a new charge.
Come on.
Thank you, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no, I'm with
Do you
you.
see why I'm so upset, Your Honor? Okay. Thank you.
Everyone loves Judge David Fleischer because he does it to make a difference. Here, after watching the video, he knew that the case was bogus and the arrest was unlawful. And once more, the defendant was saved from evil cops who just wanted to get him down under. The general rule about a courtroom is that assumptions don't work, straight up. It's either facts or it's BS, and with this case, police thought they could get away with assumptions until Judge David showed them the truth.
Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .179 and .175.
Where was he?
This looks like the man is in deep trouble because in Texas, the legal alcohol limit is .08, but the man here was found with a .179 blood alcohol content. But the car was stationary and there was no probable cause for the police to test him, and Judge David was smart enough to note that
He was in the middle of the road.
It sounds like,
He,
yeah, I don't. So it says that he was sitting inside his vehicle on the 400 block of West Gray Street, which is accessible to the public. On a public road.
don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400
My
block of
goodness.
West Gray Street. It's a public street.
I mean, I need more information. I mean, does it say he's on the street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400 block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on that.
I'm sorry, I'm gonna find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm going to find no probable cause.
you see the man was sitting in a car and was not creating any nuisance, and the report was badly written, which didn't specify that he was driving it, or again, causing harm to anyone. Sure, it was in drive and his foot was on the brake, but does that mean the cop could go on and search him? And when you answer that question, you can't find any probable cause. Hence, the case was dismissed, and the driver was let go with a warning. And there's yet another case with a similar backstory, and of course, a similar ending.
Good morning, how are you? You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop on the vehicle described by the 911 caller. The law enforcement officer made contact with the defendant, and the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting a curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues on the HGN, 3 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. The inventory search revealed 3 open and empty beer cans in the backseat floorboard and other unopened alcoholic beverages. The defendant considered to breath and blew .143 and .145.
And again, the same question, what caused the stop?
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure.
Apparently, cops can stop anyone as they seem fit, but Judge David wouldn't let that fly. There was no reason for the lady to be stopped, and then you know how that ends.
Well, the officer found the vehicle was not driving the wrong way, but it matched the description given by the 911.
Right? Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, hey, man, state's driving nuts. Go get him. Right? I mean, not,
There's
Yeah.
no other
Okay.
traffic infraction.
Spencer, I'm going to find that there's no probable cause to go forward with your case. There's enough death and destruction on our streets now. Play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand? Play it safe. Don't make any boneheaded moves. Please. Thank you.
Of course, the story ends with Judge David giving impeccable life advice, hoping to see the good in people and sticking to his morals of justice. It's almost funny that the defense lawyer didn't have to defend his client. The judge just took care of business. Now that's some good old justice. Now this gentleman managed to hurt himself, but that didn't stop the police from framing him.
Good morning, Mr. Ibarra.
Good morning, sir.
So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
And you know by now that Judge David doesn't mess around and gets straight to the point, and the same thing happened again. He asks the right questions, and then another set of cops end up looking stupid.
Okay, so was it made that, did he shoot himself or do we know that someone else shot?
We do not know. We
So-
know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it, and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending. When you hang with dogs or when you're bad places in the middle of the night, really, do something with your life. Get into school, graduate, get some knowledge. So take a seat with me.
The prosecutor couldn't convince herself about the details of the case, let alone bring it forward for the courtroom, so this one also ended up getting canned. Imagine hurting yourself and the police managed to bring you down and file cases against you. I'm just glad that this young one didn't get a rap sheet because of some incompetent cops. Can you get in an accident and flee when you're shopping in a Walmart? Well, that's exactly what happened when Mrs. Rye was booked for hit and run, but she wasn't even driving the car.
On March 10th,
Del 10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer
Princess Street in reference to an
Princess Street.
FSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger left the
oficiales
scene
dijeron que
following
un
an
white Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
en camino al sur en la calle Shaver.
The complainant stated
El
that she
quejante
was
dijo
traveling when a
que ella
white
estaba
Dodge
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero sin
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó al oficial
showed the license
y
plate,
tenía la
and
placa
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
vieron la
owner to
placa
be
y
Juan Maneno.
encontraron que el dueño era Juan Meneno.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who is
habló
the
con Juan y
defendant.
la esposa, que es el acusado.
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving the
que el
vehicle all
acusado
day,
estaba
that
manejando todo el día el vehículo
and that the only damage to
y
the
que
vehicle should have
cualquier
been on the
daño
front bumper from a
que
previous
tenía el
incident
vehículo
and
era en
nothing
la
else.
parte de frente de un accidente previo.
The defendant
Y
advised
el
officers
acusado
that she was
le
driving the
dijo
vehicle and
que
had
ella estaba
recently
manejando
gotten back from a Walmart,
el vehículo y había regresado
which
de
is around
Walmart
700 feet from
como
where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente
anybody.
y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y
information,
basándome en la
the
información dice
car was registered to his wife.
So, how do we know who's
And
driving
the
it?
complaint,
y
the
cómo sabe quién
Juan
estaba
stated that he
manejando.
was the one driving and she admitted to being in that location at the time.
Now that we have all the facts, we see the holes in the story of the police. And of course, the prosecutor just couldn't make it make sense.
Right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she
Sí.
was the one within 700 feet of the accident and that she had
Estaba
access to the vehicle, Your Honor.
tenía acceso al vehículo y estaba a 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo dijo que estaba manejando.
statement.
Dice que sí.
Do you want to add anything? Did you want to say anything?
No, well,
Yeah,
two
that
things,
was-
Judge. Number
these
one, there
are-
was no evidence that
No hay
she
evidencia.
was, as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía el
it.
vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando-
and she's using one of our vehicles, I'm sure that
Mi hija
her lunkhead
estaba usando-
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
no,
this
el novio de
vehicle
mi hija
is
estaba
insured.
manejando. Ahora el vehículo está-
There's never been
tiene
any
su- está
report
asegurado.
of anyone, but people had consent to drive it, driving it. That defense is not going to be erased, so this is an
Yes, sir.
insured incident.
It's just,
Es un incidente
you got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough,
Sure.
All right, I'm gonna find no probable cause in your case,
Va a
man.
encontrar que hay motivos fundados para mantener, pero
Please be careful when you're driving.
por favor, ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejar.
and liability insurance in your name.
Y seguro,
Do you understand?
¿entendido?
Okay, all right.
And she does, for the court's edification.
Yet another simple case that could have been solved easily was shaped into something so complicated. And yet again, Judge David Fleischer took care of business. He dismisses cases like he's cleaning dust, and that's what makes him stand out. Here's another 17-year-old who could have gotten his life seriously hurt by some police officers trying to build cases against him, but the judge wouldn't let that happen.
On June 22nd, 2024, officers of the HPD Crime Suppression Team were advised that they observed a large group of individuals gambling/shooting dice, a Class D violation, at the corner of 300 Riley and 3100 Alabama in Harris County, Texas. Officers arrived at the location and observed the defendant among the individuals gambling, and the defendant began walking away upon officers' arrival. Officers issued multiple verbal commands to the defendant to stop in order to detain and identify him for the gambling investigation. Upon detention, officers conducted a weapon pat-down of defendant's person and located a loaded Glock 19 handgun in the waistband of the defendant, unholstered with a round in the chamber. The officers identified him as the defendant.
And there we go, another round of hard-hitting questions that make prosecutors and evil cops behind them weak.
And that he was 17.
So did anyone see him shooting dice?
Officers were dispatched to individuals gambling and shooting dice, but it doesn't say that they personally observed him.
So they don't know what he was doing. He was just in the crowd.
Just that he was among the individuals gambling. I told you so.
Yeah, I know. All right. Mr. Jones, I'm going to find no probable cause in your case. Be careful, man. You're only 17. God forbid you have to use something like that and end up in a position where you're going to stuck in the pokey for a long time. Do you understand? What do you do in life, man? Go to welding school. There's no need for you to have a gun at this moment, man. You're only 17. Get to welding school. You can make a ton of money. And I'm telling you, you go do underwater welding, 150 a year. You kill it. That's what you should be. That's what you should be killing. You know what I mean? All right, go ahead, take a seat.
Hey, from life advice, saving innocent people, and now career advice, is there anything this judge doesn't do? Underwater welding may sound like an overkill due to the risks it carries, but hey, it's still better than having a criminal record, right? And there you have it, folks. Yet another case that gets thrown out for lack of probable cause, and yet another police officer who didn't get their innocent prey. Well, this is it for today's video, and I'll see you in the next one.